Hi, everyone, and welcome to On Trial, the podcast where we explore how to build your practice, trial tactics, and what can make and break your case. We're your hosts. I'm Matt Heimlich.
And I'm John Risvold.
And today I'm be asking John some questions about rideshare litigation. John happened to get a really excellent result after trial had just started, and he used some pretty great techniques to get them involved in the case, keep them in, and then, apply pressure as the case got to trial to make sure that the client got fully compensated for his injuries. So we're going to kind of explore John's brain for a little bit, use some of that expertise and see what we can do to apply it to cases in our practice. Because, rideshare companies are everywhere. They are popular. They will be ever more popular. And, they're having them in a litigation kind of throws an interesting twist in there because now it's just not a car crash case. It's something else.
Yeah, they're not just your run-of-the-mill car crash case. They are far more complex. There's a lot going on. There's a lot of data generated and a lot of information that you can get that really can help you get to where you need to go, which is either a jury's verdict or a great settlement, a great result like the one we got for my client in this one. This was an odyssey, man. This was a 2019 crash that my client was in. He was a front seat passenger in I'm only allowed to say rideshare vehicle, I guess, technically, but it's a rideshare vehicle. The pink mustache is on the front of him. You might have seen him driving around town. That driver punches it to try to beat a yellow light that's about to turn red. Left turning driver, they hit head on. And my guy had had a neck fusion about 4 weeks prior to the crash. He was still in the collar and still healing up, and ended up having several rounds of injections and physical therapy, and ultimately had to have the fusion redone completely. So he had to have they come in through the front to do a fusion and leave a tiny little scar above your collarbone. For this one, though, because they'd already come in through the front, they had to go through the back to restabilize. So he's got a pretty wicked scar from like the base of his skull all the way down to the top of his thoracic spine. And young guy, 47, really great guy, great family. Happened on the south side of Chicago, suburban south side, like 111th and Cicero. And from the get-go, it was just a matter of staying out of federal court, which is where all the rideshare companies want to play, because you don't get jury selection, you don't get, as long of a leash, I think, probably, and you have a little less favorable jury pool than you would just straight up Cook County, Chicago. So we managed to keep it in state court through some sort of clever lawyering and just kind of some good stipulations. And then from there, keeping the rideshare company sort of front and center, even when they weren't technically, after we worked out some stipulations, they weren't technically in the case anymore, but we were able to keep them front and center. And just the specter of this company, with all of its desire to not have employees but only independent contractors, and its desire to not create bad case law, sort of begins to compound as you head towards trial and create risk for them. You don't see a lot of verdicts against the Ubers and Lyfts of the world. They just don't exist. And there's a reason. The number one reason is every driver in the state of Illinois for now is an independent contractor. And those rideshare vehicles don't have to, meet the same standards that cabs do, buses, other common carriers. As of now, they will in the future. Legislation is changing that, and that's tremendous. And our friends at ITLA who helped craft and pass that legislation should be applauded. And we could talk about that as well. But for now, this one, they didn't have any sort of duty beyond, like, you're in a friend's car. And, they don't want to try cases and have their name out there because they might lose that, or they could have lost that status. Now that'll change. So it'll be interesting to see how that litigation sort of evolves now that legislation is changing to make rideshare companies common carriers and hold them to a higher standard, the same way we do with cab companies.
Yeah, that's again amazing work by the Illinois Trial Lawyers Association to get the provision that granted them common carriers. Oh, I'm sorry, it's sunsetting. So that's what they
Right.
did. It's that they currently have a privilege, and that privilege is going away. I think January of 2024 or 5, coming up real soon. But that's again amazing work by our Trial Lawyers Association there. But I kind of wanted to pause on the agent versus independent contractor concept because that's kind of where it all starts. You know, we all know how these tech companies treat these things. We don't have employees, we have contractors. We're not a transportation company, we're a tech company. How do you kind of overcome those legal hurdles and, you know, keep them in the case in the first place?
Yeah, so it starts in the deposition of the driver. The driver doesn't really have anything to gain by being the target defendant versus throwing the rideshare company under the bus. And once they sort of understand that and understand what you're trying to accomplish, it gets pretty simple. So, in depositions, you can ask things like, I'm just trying to understand how, I'll use Uber, for example, how Uber sets it up so that they get you your next ride or they get you your next customer, right? And explain to me a little bit about how the app works as a driver. How do you get onto the app, the Uber app, and how do you find customers through Uber? And I'm always talking about it being them being a facilitator of the customer acquisition, because it's not, it's not as simple as you're just raising your hand on the corner and a cab picks you up. That's pretty simple, right? But here you're actually employing the company and the company's technology, which is proprietary, in order to get the ride and make the communication. So if you do any trucking litigation, you can think about it like a logistics company that is sort of plotting the truck's point A to point B delivery, right? We keep those companies in all the time the same way. You're directing the work, you're directing the driver to a particular endpoint. You start at point A to pick up your passenger or your cargo, and then you end at point B. And this is particularly important because, especially when it comes to Uber, less so Lyft yet, they'll get there. But with Uber in particular, Uber's moving freight now. Uber has a trucking division where they're doing basically this type of logistics work and directing all of the cargo through subsidiaries in the same way they're doing it with passengers. And so keeping them in those cases is going to be really, really important. The way you do it is start with having the driver explain the how of the app. The other part of it that creates this apparent agency argument that you can make later, because you're never going to be able to win on straight agency. They're not employees. They are technically independent contractors. That's how they're, that's how they're paid for tax purposes. That's how it's all going to shake out in terms of, are they employees or not? You're not going to win on a straight direct agency, but you can win on apparent agency every single time, doing simple things when it comes to how the app works. So what I always ask is, okay, you've got a rider, you're going to pick them up. How do you get to them? Well, the app maps me there. So the app will tell you exactly where to turn. Is it similar to if I were using Waze or Google Maps? Yes, but it's built into the Uber app, right? Or built into the Lyft app itself, right? Right. So you're never leaving the native app. You're never going to a secondary app on your own phone to map the location or to map your directions. That's all self-contained in the app, and they're directing you where to go, right? Right. And then they can send you messages about a rider canceled or a customer, that you could pick up from a different location is close by, or you can line up rides through them in succession so that you can continue to pick up folks and make money. Yes. And then you can talk about the money a little bit. The only way you're making money is if the app connects you with a rider. You don't make money independent of the app. You don't make any decisions independent of it. It's directing where to go. It'll map you the best route. It'll tell you who this person is. And you're incentivized through the app as well to do a great job because you're rated by the passengers through the app, right? Right. And you can get better riders and higher quality, routes or whatever it might be through your rating. The better your rating, the more likely it is you're going to connect to somebody, right? Right. And that's all through this app. There's no decision that you're making as a driver on how to get this person into your vehicle and then where the ultimate destination is. You might make a different decision in terms of, oh, there's traffic ahead. The map says to go this way, but I'm going to go around the block. But you're still being directed from point A to point B by the app, right? And that's sort of the way you bring it all together with them, is to continue to run everything through Uber and Lyft as if they're a middleman. And then when it gets to trial, or you get later down the road and there's some sort of motion for summary judgment or something like that, motion in limine potentially to exclude you from saying Lyft, or in my case, it was a motion in limine to exclude me from saying or naming the rideshare company because they had been dismissed as a defendant at that point. And that's an insurance coverage issue that we can talk about in a few minutes if you want. That was very, very complicated, but I think it worked out in our favor. But, we're not allowed to mention them because they were no longer a viable defendant. They'd been dismissed. But, the judge denied that because the principal is out of the case, but the agent is still in the case. The agent is the driver. And so the agent can only act in concert with or from direction of the principal. So even if the principal's out of the case, even if Lyft and Uber are out, you still get to talk about them because this person is their apparent agent. And so that's where you want to develop these facts about control and about how they get paid and how the app works and how it maps and every fine detail. And then what you can do after depositions is you go back and do some supplemental discovery and get the data, the metadata from your particular ride. Get me, it'll tell you when somebody was picked up, where they were picked up, what the destination was, at what point in the crash that they actually, or at what point in the ride the crash occurred, right? So it's 15 minutes into the ride, you're 10 minutes from the destination, crash occurs. That sort of stuff, all that data is recorded and collected, and they keep it. And they have gigantic litigation divisions that are doing this sort of review and keeping these documents and making sure that in preparation for litigation, they're available. You just have to be able to request them and know what you're looking for. And you can, again, use those to further your agency, apparent agent argument. It's a lot like if you've done any med mal work, and I know you've done a ton of it, or nursing home work is very similar, where you might have an outside doctor come in and look at a patient, and the patient has no idea that they're not an employee of the hospital or the facility or whatever. And the only reason they're coming in is because the facility directed them and told them what to do. And you have your standard medical malpractice agency, apparent agency arguments. They happen like in every case, I feel like. This is very similar to that. So rideshare cases are a little bit of trucking and a little bit of like the finer points of agency in med mal cases kind of mixed together. And then you layer in this technology, which seems complicated, but it's really not that complicated. It's just like, a text message system and a Google Maps system put together that is like a two-way radio. It's really not that hard. It's just that the driver doesn't have any choice. They don't get to make these independent decisions. And that's really the key when you're trying to keep them in and trying to keep the spotlight on the defendant that has all the money.
Let's talk about, you talked a little bit about the rideshare companies and the data they keep, as well as the rating system. So they have data on your passenger, they have data on their driver. I presume that they have certain requirements that need to be met in order to drive for them. No, is that too much of a presumption?
You have a pulse proof of life. My understanding after taking a bunch of these deps is that in order to drive for the two main rideshare companies, and I don't know if this is true for like DoorDash or your food delivery or Instacart and that sort of stuff, which are separate. They're in the same vein. They're just different than the Ubers and Lyfts that are acting like taxis. Basically, you don't need any particular. You need a valid driver's license. You need to be over the age of, I believe, 18, and I guess proof of life. they're running background checks. They do a background check. They do like a driver history, but not to the degree that trucking companies do. So, there's not a federal motor carrier safety regulation rule booklet for me using my personal vehicle that it doesn't qualify as a commercial vehicle for commercial purposes. These are all commercial vehicles. And it's really important that everybody understand that these are commercial vehicles. But this is sort of a beautiful little loophole that shows the effectiveness and the power of tech companies lobbying, and why it's so important. Again, we were talking about at the beginning, for you to get involved in your trial lawyers association and for you to support, pro civil justice lobbying. These companies have created this loophole where they're letting us use our personal vehicles for commercial purposes, and they're making billions of dollars off of it and paying drivers a pittance. And there's not a safety check. So if you got a trucking company that is doing background checks of their drivers, they might miss something or they might do a half-assed job, and that happens often, especially with smaller trucking companies. I understand that I see that regularly, but here there's nothing, man. You sign up through the app. They don't really have any sort of medical screening. They don't really have any sort of real stringent requirements. You got a valid driver's license, plug it in. Your car's registration's up to date. You have your own insurance. I believe it's still a requirement, even though they have insurance. They want you to have your own. And proof of life, a pulse. That's about it. A lot of these drivers I've run into are not terribly sophisticated. They're not, they're not necessarily safe drivers. They might be, they could be, but we have no way of knowing, and we have no driver history in the same way you would for a commercial driver's licensed vehicle or driver. Your truck drivers have CDLs. They've got to go through a bunch of stringent training requirements and background checks and et cetera, et cetera. None of that exists, even though these are commercial vehicles. So it's a problem. It's a problem you can exploit, but it's usually at the point you're exploiting it, it's been to the detriment of your client or mine or whomever.
And, given the fact that these are, multi-billion-dollar companies with presumably sophisticated business legal teams, I assume that there's some sort of arbitration clause baked somewhere in some contract somewhere that you got to deal with. Why don't you tell us about that?
There's always a forced arbitration clause, because nothing corporate America is more scared of than the people. I'll hop on a soapbox for a minute. The only reason our arbitration exists in these hidden arbitration clauses and forced arbitration clauses, the only reason it exists is because they're trying to take your civil liberties away. They're trying to take your civil rights away. Your right to a trial by jury is enshrined in the Bill of Rights. It's the Seventh Amendment to the Constitution. It is the most important amendment to the Constitution, and this is the way that they circumvent it. Super, super shady. In our case, we were able to get around the arbitration clause by sort of the following. We sued the rideshare company in state court. They removed us to federal court, saying we're a San Francisco company, we have diversity, even though their driver, who was also a defendant, was here, and said that we would not oppose, remand, or enforce the arbitration clause in the rideshare agreement that you unknowingly sign every time you agree to have somebody pick you up. If you dismiss us from the case, and I said, okay, well, the condition for doing that is going to be I can continue to discuss your existence and explain that the reason my client is in this vehicle is because it's a rideshare vehicle, and the insurance coverage for Lyft or Uber or whomever has to apply. And I need that in writing. And so I had that in writing going through the litigation and into trial. And it was one of the reasons why I was able to create some chaos and leverage that got it settled in a case that probably otherwise shouldn't or wouldn't have settled if it were just a driver on driver or a driver with a passenger kind of case, because they did not want to expose themselves to an excess layer of coverage if there were a verdict in excess of the $1 million policy that they had. I don't think that there was a risk of that, just given the bills and the nature of the case, but they did. And so I'll play that up all day long. And then, walking around the courthouse for a week talking about how terrible they are and evil they are, and my penchant for using social media and broadcasting far and wide the ills of these companies. I think also, and I made it known to them, like, this is what I'm going to do. This is what we're going to talk about. I'm going to blow these pictures up and you're going to see this front end damage. And the only thing you're going to see is the rideshare sticker and the front end damage and the airbags off. And I'm going to leave it up there and let them make their own decisions and make their own conclusions from it. That was able to sort of jar them into a settlement position that I think was very beneficial. But they have these arbitration clauses. There's a couple things that you can do. One, if the person who made the reservation is not your client, that arbitration clause does not apply. Simple as that. It's a lot like nursing home arbitration clauses, right? If the individual who's hurt didn't sign the particular form, it's moot. The other thing that you should always fight on, I didn't in this particular case for a couple of reasons that were more complicated and it would take a long time to talk through, that have nothing to do with rideshare litigation generally. It had more to do with a treating physician, my client. But in this particular arena where you're dealing with these arbitration clauses, your driver is going to be local, and there's not going to be diversity between the driver and the plaintiff. And so what you need to argue, and sometimes you need to go do a little bit of discovery, maybe in federal court, before you can fight off an arbitration clause or file your motions to remand or whatever it might be. Do a little bit of discovery, get your agency or apparent agency testimony sort of lined up. And then you can move to remand to state court and argue that they are, the principal. And yes, they're located out of state, but the agent, their independent contractor, is here, and your client is here, and the crash occurred here, and so it should be in state court. And you're going to win that argument 9 times out of 10, especially in the Northern District in Illinois. I don't know, wherever you might be listening to, whoever your judge is, be wary or aware of the types of rulings they make on these things. But these arbitration clauses are sort of contracts of adhesion as well. Nobody knows that they're there. Before I ever sued one of these companies, honestly, and I'll admit my own ignorance, I used them hundreds, thousands of times with no idea that there was a forced arbitration clause until the first time I sued them. You should just, assume that everything you do, they're going to try to force you into arbitration. For those that don't know, arbitration is it's like a faux trial where an individual, usually a retired judge or a panel of retired judges, will decide a case. Plaintiffs are at a distinct disadvantage in these things because insurance companies are in front of the arbitrators all the time. And these mega corporations, these tech companies, are in front of them all the time. And you might be in front of them once or twice. And so it's just a home field advantage sort of thing. I think that, there's a reason why we have 12-person juries. There's a reason why we have civil jury trials. There's a reason why it was enshrined in the Constitution. And it wasn't so that we could hire retired judges to decide these cases in our favor over and over and over. If they wanted a bench trial, they shouldn't have filed a jury demand, or they should have moved to vacate ours. But avoid arbitration at all costs. The other way to do it, if your guy's not, or gal is not, going to be able to sort of opt out because somebody else booked it for them, is sort of the same way that you would do it, I think, and we've talked about this, in a nursing home context, where you're talking about, do they appreciate what they're actually signing? Are they made aware of it? Is there somewhere in the app, when you go to book a ride, where, for instance, a pop-up pops up and says, I agree and acknowledge that by booking this ride, I agree to venue clause, arbitration clause, whatever it might be. Those things are harder to get around. But if you're just pulling it up and booking a ride from point A to point B, and that doesn't pop up, and it's somewhere buried in a receipt that you get later, you have a good argument that there's no way that your client could have appreciated that this even existed or agreed to it. And if they had known, they wouldn't have agreed. And they're not agreeing to contract their rights away. But those are issues that you can either fight and they'll fight you on those tooth and nail because they want to keep these cases out of the courts. They want to keep them out of the limelight, away from juries, because they know that juries understand that it's a big corporate defendant with a lot of money that doesn't really care about safety, that doesn't really care about your client, and juries are going to hit them because there's little tolerance for that type of corporate malfeasance, I think. And clearly they think so because they're working really hard to keep these cases away from juries. So you got to fight that or find a loophole. We were able to work that sort of stipulation loophole. In fact, the stipulation that we got the defense lawyers to agree to was so favorable to my client that the rideshare company pulled the file from that defense firm entirely and sent it over to a brand new defense firm about 2/3 of the way through the case in reaction to that, and pitched a huge fit about it. And, it caused all sorts of problems for them down the line because they had lawyers who took over and didn't know what was going on in the case and didn't know what they were walking into. And we were able to use that to our advantage as well. It's a lot of these is just about creating leverage against them, really, and outworking them.
So when it comes to triggering the coverage, 'cause you talked about the drivers need their own coverage, at least some degree of coverage, and then there's an additional layer or layers provided by the rideshare companies. What is it that triggers coverage? Is it the app is on, they're going to get a rider, they have the rider, they dropped off the rider and are getting somebody else? Well, how does that all work in your experience?
The only thing that I feel that these companies are perfectly transparent about is how their insurance works. And it's sort of a tiered system. So you can go on their website. I'm on both of their website. I have both of them pulled up. So for instance, Lyft has third-party liability insurance, which covers the vehicle that the driver's driving. And the way it works is that it's tiered. So there's $50,000 for bodily injury, $100,000 per accident. Very low limits. And then it goes up from there. So that's coverage when the app is on and waiting for a ride request and the driver gets in an accident. There's only $50,000 in coverage. If the app is on and the driver's en route to pick up a passenger, or that it happens during a ride, there's an accident, there's $1 million in coverage. So if they're on the app, but they're just driving around and they're not going to pick somebody up, or they don't have a passenger, there's very minimal coverage, only $50,000 in coverage, which is another reason why we also should reemphasize to everyone, go get as much uninsured or underinsured motorist coverage as you can get. It's worth every penny. It's the only insurance that actually protects you. If they're going to get somebody or they have somebody and they're actually actively driving for Uber or Lyft, there's $1 million in Lyft coverage. Uber works basically the exact same way. If you are an available driver or you're waiting for a ride request, there's $50,000 per person. And if you're en route to pick up riders or during trips, there's $1 million. Now, where it gets sort of a little more murky is when there's uninsured or underinsured coverage. So, for instance, Lyft before a certain date, and I don't know exactly when it shifted, but if you have a Lyft crash before 2020, you have $1 million in uninsured or underinsured coverage. After that, it depends on your state. I know here in Illinois, after that, it became $250,000, and that's it. So not a whole lot. The same with Uber. There are varying degrees of uninsured and underinsured coverage. And so what you should do, or what your attorney should do if you're not an attorney, or if you are an attorney, you should go on these various company websites and say specifically, or find specifically, what the coverages are. And then you get into discovery, you get into your written discovery in particular. You want to request, your deck page of the policy to make sure you're getting the policy. You want to request any layers of coverage, because they all have various layers of coverage, all the way up to, tens and tens of millions of dollars of coverage that exist up there, up the chain. But you also want to ask, what phase the driver was in. Or did they have a passenger and they caused an accident? Were they en route to get a passenger? Had they just dropped somebody off and they're waiting for the next one? So they just dropped somebody off, they're waiting for the next one. That's the 50 grand. If they're en route to get somebody, that's $1 million. They're going to fight you on that all day long. They're going to fight you on they just dropped somebody off and they weren't yet going to pick somebody up. They were waiting for the next one. A lot of these drivers line up their rides. So you got to ride, and you'll see it on the app. Like, your driver is finishing a ride nearby and then will be there, right? So if that driver is dropping somebody, and then once that door closes and they drive off to pick up the next person, that's $1 million in coverage. And so it's very important you find precisely where they are in the process so that they can't use any little tiny window to create coverage denials or to push you into the lower end of the spectrum of insurance coverage. Making sure that you are in that $1 million range, and especially if it's a much more significant case, you've got a permanent injury, a death, something like that, where you know you're going to crack layers of coverage, you got to be out of that $50,000 range. So it's really important to get testimony from the driver that says, hey, this is what I was doing. I was on my way to get the next person, right? They don't know these nuances. The drivers don't, because they're not trained. They're not trained by Uber or Lyft to figure these things out or understand them. The defense lawyers may or may not know, depending on, how much work they do for these rideshare companies. But it's really important you get the driver to say that they were on their way to get somebody if they didn't have a passenger. Data can back that up too. So you can get that data and discovery, and that can be helpful.
Yeah, that was my next question. I mean, I imagine the key to, objective evidence confirming that would lie in the app, in the phone, depending on what the driver's doing. How have you been successful in getting to that kind of data, and how do you do it? Is it subpoenas? Is it through the driver? How have you been able to kind of uncover that kind of irrefutable evidence that we'd all like to have?
It's not through the driver. The drivers have testified repeatedly that the app only stores a certain number of days of data. I've had one driver say it's only 14 days. I've had another say it's 6 months. But if you've got a case like mine where it was a year old, it was a year after the crash before they even came to me, before it was referred to me, by that time, the driver is not going to be a source of data. So you got to subpoena it directly from the company. Part of what prompted the insurance stipulation I've discussed earlier was they don't want to turn that data over. So if you draft a very detailed, like if you have a good preservation letter that you use in trucking cases, or if you've ever gotten audit trails for medical records in a nursing home or a med mal case, you can take a lot of that language about metadata and all of the associated software needed to read it and reports and what it can generate and everything else, and put together effectively a subpoena with a rider that says you need to produce all data concerning what rider they were going to pick up, the rider's rating, the distance, the timestamp for when the ride was accepted by the driver, the timestamp for when it was requested by the rider. All those things are marks of data, right? The time it took for the driver to get from point A to the point of the crash is recorded. The time it took to get to your destination, all these things have data points. So just you want to request every single one of them so you have objective measure. I can tell you that I have never gotten complete set of this data ever, but requesting this data has prompted either them to give up this fight on coverage completely or has prompted settlement. I've had, a couple of cases where I request this data as part of just a regular request to produce in discovery, and they go through it, they object to it. I do the 201k, threaten a motion to compel, have a discussion, and it's like, well, why don't we mediate? Maybe we can resolve this one early. And they don't want to give up all that information, all that data. It's all proprietary. It's all something that they consider trade secret and they consider to be, the holy grail of their business. And so you're going to need a motion to compel more often than not to get it. But if you request and push for it, you can position yourself to either have them give up the fight on coverage or get the data that proves what you need. If you get early enough in the case, the driver might have it still, and you might be able to get it from the driver, especially if you can get a deposition quickly. You might be able to just have them pull out their phone and look it up while you're sitting there. But for the most part, they're going to guard those secrets carefully.
Oh, I'm sure they want broad protective orders too. Can't even imagine. But let's say, like in your case, you reached a stipulation about the coverage. You've got, I assume, some underlying insurance through the driver, and then over that you have the rideshare insurance. Tell me how you think that dynamic played out towards getting, the settlement you thought, your client ultimately got and deserved. Do you think that there was leverage there? Do you think that, there was downward pressure from the rideshare company to get the underlying case done? Tell me how those dynamics kind of work themselves out, especially, on the eve of trial as everything's about ready to go.
So in my case, unfortunately, or fortunately, depending on how you look at it, an adjuster lost her job. And I can tell you why. So you've got my guy's a passenger in the rideshare, and the rideshare vehicle has the right of way, but slams on the gas on a yellow light to try to beat a red. And they enter the intersection on a red light, and the other vehicle was uninsured, the other defendant, the turning vehicle. Turning vehicle had the majority fault. If the turning vehicle were the lift, it would have been a case where it probably would have settled for more than it did. Turning vehicle had no insurance. And at some point early on, Lyft wanted to mediate. We mediated, and it was a failed mediation. Or the rideshare company wanted to mediate. It was a failed mediation. And we went forward with the thought of, put all of the onus on the rideshare company because that's where the value is. There's no insurance over here. And then the defense lawyers reached out to me and said, well, there's $1 million in uninsured coverage. Maybe we can just work it out that way. And then we came to find there was only 250,000. So they offered that. And I said, no, the Lyft driver has the majority fault, is, the majority of fault here. And so they're going to have to pay something. Uninsured motorist coverage and underinsured motorist coverage does not stack typically in Illinois. So if I have an uninsured policy and I'm a passenger in a vehicle, my policy doesn't stack on top of the existing policy typically. But here, Lyft's own policy applied to both defendants. So we were able to get the full policy limits from one and then work backwards to get the other policy, half of the other policy basically, paid. And we create the leverage that was created was an adjuster, God love her, put in writing, we believe we have a 20% fault, and we're willing to tender the full UM limits rather. And here's how we value the case, and gave me an itemization, $180,000 in bills, $400,000 in pain and suffering, $200,000 loss of normal life. And that was it. But reduced by 80% because we're only 20% at fault. And I left the uninsured driver in the case. I never accepted that tender, and I never dismissed them, because when we got to trial, I have this other defendant out there who has not appeared, isn't in the case, doesn't have insurance. And that created a ton of leverage because I then get joint and several liability. And I can say, look, if the rideshare driver is found to be more than 25% at fault, they're on the hook for the entire verdict. And that drove a ton of the value. And they realized, oh, we're in trouble. This guy's still in the case. We haven't done anything to dismiss them. We didn't file any motions or default them. They were never defaulted. They were never settled out, nothing. They're still a viable defendant. And so they're not going to have any defense. We got to either blame them 100% as a defense, or we have to try to attack causation or whatever else. But they didn't at that point. The point they realized it was at trial. They had no experts to combat this. They had no real way to fight it. And so we were able to leverage much more of the larger policy on top of the because they just took their eye off the ball. They didn't realize how joint and several liability worked, that I only needed to prove 25% as opposed to 50%. And that was a deliberate choice, knowing that a jury could have said, no, the turning driver is 100% at fault. But I think you sound like a reasonable person in front of a juror when you say, or a jury, when you say, split it between them and make them both equally at fault. You look really reasonable, and they look ridiculous to say, nope, we're here, we want 0% fault. No jury is going to look at that objectively and say, oh, well, the plaintiff's lawyer is only saying 50%. That seems super reasonable. And if the other person, was here, if they were still in the case, they would be here and they would have a defense, but they must have already settled out or done something, who knows? And the jury's trying to figure out why they're not here and says, okay, 50% works for me. And that was the argument that we made all the way throughout until eventually, in the midst of, after 4.5 days or so, we were able to settle it at trial, just because they knew that there was a huge risk to them that a jury thought we would be very reasonable in asking for only 50%.
No, it's so smart, so strategic. And it is unfortunate that sometimes you have to go to those lengths, to get what seems to be a fairly straightforward concept across, to the other side. But that's why we do what we do. Sometimes it does. You have to take them all the way there. And sometimes the like you said, adjusters get fired or removed, and new firms come in and they have a fresh set eyes, and they're seeing things that the prior firm wasn't. So it sounds like quite a journey to get where you got with what on the outside, not knowing all the intricacies, seems like a fairly straightforward intersection case. But as we've been talking about, there's a lot more to it than that.
Yeah, and I'll give you the last sort of wrinkle to it that has nothing to do with rideshare companies. About 2 weeks after the close of discovery, when we had already had the case certified for trial, my treater, the surgeon, backed out completely and said he refused to testify, and went off the grid, and we had no causation testimony, and I had to file a motion to reopen discovery, to hire an expert to testify to causation. And that became a huge fight and a huge point of leverage for them, because they had motion after motion after motion to bar this person. And thankfully the judge was smart enough to see through that and see it for what it was. But we had that all locked up, and then all of a sudden this guy went AWOL. So it was very hard fought. It was very complex, this one in particular. But that's the way that they want to make this litigation. They want to take a simple intersection case and make it incredibly complex. And what we need to do is continue to look at it sort of as two-tiered. One, it's a simple auto case at its base facts, right? In terms of liability. The complexities are, how do we get the insurance coverage triggered? How do we get the jury to hear about the actual corporate defendant? And that's where it gets complex, in the same sense that like a trucking case would get complex. But there aren't hard and fast rules to follow. So you're just kind of off in the wilderness, David and Goliathing this thing against giant tech companies that are publicly traded and will do whatever it takes to keep their shareholders from exposure and keep their secret secret.
Yeah, it's an uphill battle for sure, but we're making progress one case at a time. You managed to keep them in the whole way and get the recovery that made sense for everyone under the circumstances, especially in the face of a fly by night treater. There's always something. Why would anything go smoothly? So
never a dull day, that's for sure.
Absolutely.
Right?
Absolutely. And so I think we're going to leave it there with that. I want to thank you for sharing all the, tips and techniques it took to get, a great result against, these rideshare companies, and, keeping them in there. That's the important thing. It's just making sure it sticks, and then using the leverage that you have, to get the result your clients deserve.
Yeah, for sure. No, it was hard fought, but there are no more deserving folks than my client and his family. They're just wonderful, wonderful people. And the nice thing about all of this is I feel like I've made some good lifelong friends out of them and their family too. So there's a nice silver lining.
No, that's great. Nothing better than getting a good result for the client and getting the genuine appreciation that comes with it. That's awesome. We're going to leave it there, but before we wrap up today, we're going to give you our 30-second trial tip. One thing that we do to make our cases stronger and our trials better. John, what's yours for this week?
Yeah, take every case that comes across your desk and treat it as if it's going to be presented to a jury. Treat it as if it's going to be tried, and then work backwards. Work backwards from trial to discovery, and you will end up ahead of the defense lawyer and ahead of the insurance company or the corporate defendant or whoever, because they're not thinking about cases like that. They're thinking about them linearly from start to possible off ramp of settlement to finish. And if you think about them backwards from how does a jury understand these facts? How does a jury get to see these particular pieces of evidence? What demonstratives can I use? You'll be a leg ahead. One thing I've started to do is started to mark exhibits in depositions as trial exhibit 1 or trial exhibit 2. And when defense lawyers hear that, it kind of is like they perk up a little bit and they think, what did he just say? Trial exhibit. We're in the beginning, we're in a plaintiff's deposition. They're just not thinking about cases that way. And you can get a huge competitive advantage thinking about them that way.
No, that's really smart. I was always told, read the jury instructions, read the jury instructions. I can't say I listened right away, but eventually I did come around. And yeah, you should. Everyone should. They should start there at the end and work your way backwards. Mine for this week, kind of based on an amazing result that 3 lawyers at my firm got on a nursing home case, $5.5 million on an admitted liability wrongful death case occurring at a nursing home for a woman who, according to our own experts, had less than a year to live. An incredible result for an amazing family. But my big takeaway from their result was even in an admitted liability case where there's wrongful death is an issue, the manner in which the person died can be and almost always is relevant, even if liability is admitted. That was hard fought in the motions eliminate stage, but the judge eventually ruled in our favor that knowledge of the circumstances of the decedent's death can increase the grief, sorrow, and mental suffering suffered by the family. Because a lot of times what you'll see, in really bad, rear end cases where liability is undisputed, or a lot, even in the nursing home context, you'll see that sometimes where all the bad facts are liability facts. So the defense attorney is going to say, hey, let's just admit liability and try the case on damages. And that's what they tried to do here. And, they thought it would keep a lot of the bad facts out. But, we were able to argue the relevance of the circumstances of the death. It's not like you can't just take that out of context. You can't take this person died without any of the surrounding circumstances, because then there's no association with the family. Like how would they learn how it affected the family? Because they know all this. They know what happened. And in that case, one of them was actually there. So it was just a very traumatic experience. And, this is something that, and in their case, the award, more than half, I believe the award was for grief, sorrow, and mental suffering in the family. So it just shows you that even, they try to take that away from us by admitting liability. They try to, short circuit our story and take, issues off the table, but, they're still relevant. There's still ways to get them in. And, even in those circumstances, there are ways to get those facts that really show the jury, the value in these cases.
Yeah, let's not understate that result though either. $5.5 million in a nursing home case with an individual who had less than a year to live by your own expert's admission. I mean, that is just incredible lawyering. It's an incredible result. It's a very deserving family from what you've told me and what I know, what little I know. But what an incredible result. And to your point, incredibly important bit of work there in the motions in limine, because it's not enough to say that somebody died wrongfully. It's how they died impacts how these individual family members will grieve and suffer, right? Like if somebody witnesses it, which one of the clients did, that's going to have a devastating impact on them, certainly. And so just a masterful job by you all and your firm. And just, I can't sing the praises of this result enough. I think it's just astounding in such a good way. It also just gives you hope for, society and juries and the system and all of it, that they can sort of see through the game playing, and that a judge is smart enough to see what's going on and is fair enough to understand that this is the way that it should be. That result's tremendous. So what a great job on damages, and what a great way to spin liability facts into damages very effectively. Super awesome.
And that's going to be our episode for today. Remember, you can follow us and send us comments, questions, and episode ideas on Facebook, Instagram, and then Twitter at On Trial Podcast. Please also rate and leave us your feedback on iTunes, wherever you download your podcasts. And until next time, we'll see you on trial.